Welcome to Gas, the true story of a toxic train derailment. I'm Ron Scholl. Last time on Gas, we considered competing theories for why the Alberton derailment occurred and how federal preemption threatened to derail plaintiff's argument. We also examined the burden of proving liability or negligence against MRL for the derailment and any injuries, and of seeking punitive damages. We now continue with Part 6, Chapter 22. Austin v. MRL. Epigraph. There was no way any human being could have seen this happening. David Potter, MRL defense attorney. By 2001, less than 90 Alberton cases survived the catacombs of the legal system. They persisted in part because plaintiffs and their attorneys wanted to prove MRL was at fault for the Alberton spill. MRL attorney David Potter called the first of Ted Lyon's cases to go to trial a test case to determine liability for all others. If money mattered, the stakes were sky high. 21-year-old Sam Austin and his two cousins were caught in the chemical cloud as they drove toward Missoula on Interstate 90. Austin experienced numerous daily asthma attacks throughout the following weeks, along with dizziness, nausea, and nosebleeds. He had a childhood history of asthma that seemingly resolved by age 13. After his Alberton exposure, Austin described a mild attack as trying to breathe through a straw. The following summer, while Austin lived on the West Coast, his renewed asthma worsened. The morning after Christmas 1996, he awoke frantic, unable to draw a breath. Turning blue, he thought he was dying. After repeated attempts, he managed a heavy wheeze and was rushed to an emergency room. In 2001, Austin still used 3 inhalers daily, including steroids with potential side effects. A former University of Montana student who had run up mountains, Austin now got short of breath walking. Formerly an avid swimmer, he wheezed when exposed to chlorine in pools. Smoke, exhaust, household chemicals, even everyday dust were triggers as well. He couldn't mow a lawn because of the fumes. Austin testified that every time he had an asthma attack, he feared he might die. He had 3 to 4 significant attacks a week during the day and another 3 to 4 significant attacks that woke him at night. Doctors said his condition would worsen with age. Austin also suffered from chronic fatigue. Now 26, Austin would test the waters for the remaining 86 clients represented by Ted Lyon and co-counsel Grady Chandler, a couple of Texans. This federal case paralleled Lyon's Griffin et al. Cases in the county district court. Lyon, 53, was a wrongful death and personal injury attorney who had handled murder cases as well. With a distinguished track record, he had the war chest to fund the Alberton cases. In his Texan drawl, Lyon appeared more emotional and informal than the staid Chandler, who moved about the courtroom carefully and spoke with little Southern accent. Chandler, 48, of Garland, was a personal injury and products liability attorney. He and Lyon were both rated as Texas super lawyers. Lucinda Hodges wondered how a Montana jury would view out-of-staters against the homeboys, especially with a Montana corporation on the line. Lead counsel for MRL, Randy Cox, 48, had varied expertise including toxic tort defense. In the middle of a distinguished career with Missoula's Boone Carlberg, Cox would go on to be a Montana super lawyer. Cox delivered a quiet folksiness, reserved when cross-examining, outright affable with his own witnesses. He mastered the art of earnestly asking a defense witness a question as if the first time. When reason dictated, they'd rehearsed to the hilt. When Cox questioned some key MRL employees, even their hesitations in answering seemed calculated to break up any feeling of orchestration. In sharp contrast to Lyon, who at one point apologized for raising his voice, "I get carried away," he said. Cox often made his objections in a patient, almost meek tone. Co-counsel David Potter of the Minneapolis firm Oppenheimer, Wolf, and Dunley was a 46-year-old with a gift for rapid, intelligent articulation. While Cox handled the personal injury side, Potter focused on the railroad. The jury consisted of 1 woman and 6 men, all over 30 years old. Over the next 2 weeks, the gallery was split between a dozen or more MRL supporters, mainly attorneys, on the left and a dozen or more Alberton victims on the right, with occasional attendance by the media sprinkled down the middle. On April 2, the gavel dropped. Magistrate Leif Erikson presided, age 59. In his opening statement, Lyon claimed MRL had allowed their rail to become totally worn out and committed drive-by inspections of their track. He ran down the history of MRL's safety record and Curve 155, claiming MRL did nothing to prevent the derailment. Sam Austin, formerly 110% All-American healthy, now had reactive airways disease syndrome, was chemically sensitive and prone to infections, using inhalers 3 to 4 times a day. Lyon emotionally concluded, every health problem he has today was caused by MRL, who acted in disregard for the money. Cox responded with an air of common sense logic and a prop, a green styrofoam model of a rail section. The plaintiff's overstatements were a scare story, he said. MRL had no warning of the disaster to come, and rail wear had nothing to do with why the rail broke that morning. Furthermore, MRL conducted careful inspections, though in this case there had been nothing to see. The vertical split head formed quickly and broke out with the derailed train. As for Austin, 17 million Americans had asthma, and Austin had no current impairment, Cox claimed. He quietly asked the jury to be practical. For over 5 days, Lyon and Chandler built their liability case, starting with reluctant witness Billy Shutter. The former engineer called the BN maintained track very smooth compared to MRL's line, which he described as like pulling off a highway onto a dirt road in some places. Shutter related his pre-derailment conversation with MRL President Bill Brodsky about rough track, and Brodsky's remark that with heavy traffic it was hard to keep track maintained. On cross-examined, Potter asked if they had talked specifically about Curve 155. No, Shutter admitted, but we were talking about pretty much the whole system. On April 9, though, just 36 hours before the fateful derailment, Shutter had thought Curve 155 was okay as he rode west on it. Next to testify was Bob B.J. McComb, who had tried to help the engineers that fateful morning. McComb retired from MRL in 1997 after 41 years in railroading. As a signal maintainer, it was part of his job to report broken rails because they could affect the track circuit. McComb recalled a September 1995 conversation with MRL Chief Engineer Richard Keller about Curve 155. I thought the rail was getting bad. Keller asked, "Are you a track engineer?" I said, "It's a lot easier changing rail than picking up a derailment." McComb had noted rail slivers, the bowl so worn down that the gauge face was peeling off. He thought Augie Cantu and Earl Perrine, both good, hard workers, who tried to keep the track safe, but compared to BN, McComb called track conditions in his same territory under MRL shabby. We had rail that was worn so bad the wheel flanges run up on top of the joint bars, he said. Under cross-examination, McComb seemed hostile towards Cox, bristling with terse replies. Grady Chandler next questioned Chief Engineer Richard Keller for hours about rail wear and the history of Curve 155. At one point, he asked Keller if he knew that one or more trains had reported rough spots in that area. I don't know that, Keller replied. Chandler produced an April 15, 1996 memo from Keller to all roadmasters, telling them to have dispatchers immediately put out a slow order when rough spots were reported. Chandler was fishing, but Keller's other exhibited memos had been reactions to conditions. Rail wear, vertical split heads, and roadmasters not having calipers and hand mirrors. Was this memo a result of reported rough spots not getting proper attention? Chandler asked. No, Keller denied. So why did Keller produce the memo on slow orders? Chandler asked. The memo didn't generate from a reported rough spot from Curve 155, Keller evasively answered. Chandler pressed on. Why was Keller suddenly ordering a safety precaution for rough spots? Was Keller sure nothing about the Alberton derailment 4 days earlier, which resulted in a toxic spill and mass injuries, caused him to write the memo? Yes, Keller said. He was sure. Only under cross-examination by Cox did Keller claim the memo generated only from the April 11 Knoxon derailment, which occurred 30 minutes after Alberton's. Under redirect, Keller told Chandler there had been a, quote, question as to whether the Knoxon rough spot had been reported or not. The dispatcher was supposed to automatically put a slow order out upon report. Keller then claimed that he did not know that the Knoxon rough spot had been reported prior to the Knoxon derailment. Keller was contradicted by Shutter and Caswell's claim that they and other crews had reported the Knoxon rough spot to dispatch for a week and a half, and yet no slow order had been issued or repair done. Knoxon mattered because it could set a precedent for reported rough track not being slow ordered and its repair being deferred. If it had been reported, this raised the question of what was the process, if any, for documentation of reports of bad track. But plaintiffs did not pursue how such reports were documented or archived. In his deposition, however, Keller had said the April 11 Knoxon derailment was caused by a broken joint bar. After a train reported a rough spot a few days prior, Keller had said, the roadmaster had the joint raised up. The night before the Knoxon derailment, another crew again reported a rough spot, but Keller had testified in deposition that MRL came to the conclusion, quote, it would last until morning. It almost did. Regardless of these contradictions in testimony, Keller claimed in court that his memo generated from the relatively minor derailment, not the catastrophic one, or both, and though he wrote the memo, MRL's chief engineer now claimed not to know if the Knoxon track had been reported. Keller originally answered Chandler that the memo had not generated from reported rough spots. But if slow orders had been routinely issued subsequent to bad track being reported, then why write the memo? Though Chandler didn't draw it out, it appeared Keller at the very least had been concerned that the Knoxon rough spot, if not others, might have been reported and yet not slow ordered while left to, quote, last until morning. Chandler produced another memo generated April 13, 2 days after the Curve 155 derailment, in which Keller reminded roadmasters to occasionally ride trains to help detect rough spots, per MRL policy. Keller admitted that there might have been some roadmasters not doing that. But regardless of the timing of these memos, none tied actions directly to any report of a rough spot at Curve 155. When CF&I had received unbranded rail fragments from Keller to test, they made note of rail brand CHX3473A, based on a note sent along from Keller. Keller told Chandler the brand information was a mistake. It wasn't clear what mistake Keller meant. After Keller's examination, Chandler later read from the deposition of FRA's Lee Klaus to establish that Klaus saw a branded A-rail piece with a vertical split head in Keller's office, and that Klaus told Keller to send that piece to CF&I. Chandler failed to ask Keller what happened to the branded Ghost Rail, the only evidence of such a brand. No brand had survived among the many fragments of the failed rail that plaintiffs ever saw. Cox asked Keller that given what he now knew, was there anything he would have done differently before the derailment regarding Curve 155? In refrain with employees to follow, Keller resolutely answered no. Later on the stand, witness Augie Cantu defended his use of the term ball worn out to describe Curve 155 in January of 1996. He had been simply confirming the earlier decision to relay the curve. It was in the process, he said. Everything was okay. If there had been anything wrong, he would have taken action. Ball worn out, he said, was a neutral term to me. When asked if any train crews reported a rough spot on Curve 155, Cantu replied, I don't remember any. From 1987 and 1988, and again in 1996, Dan Watts was Vice President of Operations, whose primary responsibility was the safe and efficient operation of the railroad, he testified. MRL had eliminated the position for 8 years, delegating the responsibilities to President William Brodsky before resurrecting the VP post just prior to the Alberton derailment, coinciding with the burgeoning of MRL's rail problems. Watts had previously spent decades with Northern Pacific and Burlington Northern. Note, like many other local MRL employees, Watts enjoyed a promotion post-Alberton, becoming MRL president in 1998. Soon after the derailment, Augie Cantu was promoted to the new position of General Roadmaster. In 1997, William Brodsky became president of both MRL and I&M Rail Link, before becoming president of Washington Transportation Group. "That's your first responsibility, safety," Watts said in court. But then he added, "safety and efficiency. There needs to be a balance." 50-something, Watts seemed somewhat a deer in the headlights on the witness stand. As vice president, Watts said he held the people beneath him accountable for safe operations. Lyon: "Name one person you've held accountable for the derailment." Watts: "No one. Based on the facts, there wasn't anybody at MRL that was accountable." When Lyon asked Watts if MRL had consciously, intentionally, deliberately decided not to replace Curve 155 prior to the derailment, Cox objected but was overruled. "They made a decision to relay that curve in 1995 for 1996, Watts answered. Lyon said to listen again to his question and to answer yes or no. Watts repeated his answer. Lyon tried one more time. "Yes," Watts finally said. "A decision made by top management officials?" Lyon asked, raising his voice. "Yes." But this tug of war meant nothing. When asked by Lyon if he thought a railroad should exercise extreme care concerning rail wear, Watts answered yes, and that you should exercise extreme care in all operations. But such an opinion would do nothing to solve the legal issue of standard of care. As for rail wear relay standards, Watts said that a standard and guideline is the same thing in my estimation. Lyon didn't pursue exactly what that meant. There was little give on either side. When Lyon brought up B.J. McComb's pre-derailment warnings about rail wear on Curve 155, Lyon asked Watts, "He's a good man, isn't he?" "I believe he's a signal maintainer," Watts deadpanned. Watts backed up Cantu by saying a characterization of ball worn out would cause him no concern, though regarding Keller's memo account of entire curves worn way below MRL standards, I'd be fairly concerned, Watts conceded. When Watts was on the stand, Lyon attempted to extract from him an admission of liability for the derailment based on his past public comments. What he had meant, Watts said, was MRL accepted responsibility for the evacuees and took care of their immediate needs. Lyon tried another approach later when he called Sylvia Bookout-Reinecke to the stand. Bookout-Reinecke, a state representative, lived on Plateau Road and was a client of Lyon. "What did Watts say at the public meeting?" Lyon asked. "I heard him say, 'We take full responsibility,'" she answered, with apparent restrained anger. Watts added, she said, that MRL would be with us for the long haul. Cox fruitlessly objected. Bookout-Reinecke also had spoken directly with Watts at the time, she told Cox in cross-examination. Cox asked if she thought Watts meant legal liability. "I don't understand," she said. "Full responsibility means full responsibility." She started to cry. "I'm getting upset here." "Did Watts mean MRL could not argue negligence in a court of law?" Cox asked. "At the time, I felt relieved," Bookout-Reinecke answered. "It didn't ever enter my mind that it'd be in a courtroom." When the first rail expert hit the stand, Potter chimed, "Here we go," and plaintiffs called rail experts Edward Cox, Ronald Dunn, and Edward Stanton to present their theories. Following testimony from medical and financial experts and Sam Austin, on the sixth day of trial, the plaintiffs rested their case. Now it was the defendant's turn. Soon after MRL took over, Magistrate Erickson excused the jury and listened to arguments on MRL's motion regarding punitive damages. MRL said the plaintiffs had provided no evidence that MRL knew about the vertical split head or knew that the rail was broken. Nobody at MRL saw anything, Potter concluded. Furthermore, as for predictors of the vertical split head, A-rail and rail wear were preempted. An argument that MRL relayed the curve too late was at best classic negligence, though MRL had consciously planned the relay. Chandler ventured an analogy of a drunk driver's excuse of, "I couldn't know there would be traffic on the road or that my last drink would be one too many." MRL had plenty of red flags to predict the rail failure in curve 155, he said. Chandler also tried to argue that rail wear and A-rail were not preempted by the Federal Railroad Safety Act. There were simply no federal standards. Magistrate Erickson said the main problem for him was determining the actual cause of the vertical split head. A-rail was clearly low quality, but it was the industry standard to use it, he generally opined. The timing and visibility of the vertical split head was disputable. Even considering wear, there was no evidence that MRL was on notice of the vertical split head. Though one might criticize MRL regarding their policy on wear limits and A-rail, wear limits were a matter of negligence, not recklessness. Erickson ruled that the case was restricted to negligence and compensation. The jury would not consider punitive damages. The jury was not told of this ruling until just prior to deliberation. The stakes had lowered dramatically. The next day, Erickson also excused BN as a co-defendant as BN abruptly settled with Lyon. Privately, Lyon was happy. It wasn't a high settlement, but it would help greatly in defraying expenses. He disagreed with Erickson regarding whether the MRL-BN lease contract required MRL to live up to BN standards. Lyon said Erickson had been leaning toward excluding BN in the case, but BN was concerned about a Montana Supreme Court appeal and the cost. The question of whether BN had a contractual obligation to oversee MRL and the rail line would not be answered in these cases. Now Lyon focused exclusively on MRL. Riding high, MRL pushed on with their negligence defense. On the stand, former roadmaster Roger Babcock answered a question from Chandler about curve 155 with, "That was a good curve." When Chandler held up fragments of the rail, Babcock added, "After the derailment, it wasn't a good curve." Curve 155 had been Babcock's territory for the better part of 35 years. As assistant roadmaster, he spent 90% of his time inspecting track. He became a roadmaster in February 1996, after which he spent about 20% of his time inspecting track. Babcock was one of the few key personnel in the Alberton scenario not to get promoted following the derailment. In fact, Babcock dropped 2 rungs down to his pre-1995 job as section foreman in late 1998. In court, Babcock claimed the demotion and a $10 an hour drop in pay was voluntary. "The job was too much pressure. I couldn't handle it," he said, without explanation. Babcock offered the closest thing to an apology ever from an MRL representative for the Alberton derailment. "I feel sorry that it happened," he said. "I lived there. If there was something I could have done to undo it, I'd undo it." In court, Chandler finally made a connection between the wear on curve 155 and MRL's standards for transposing rail. Curve 155 had vertical measurements as low as 2.51 inches back in 1991. "This was within the transposition range, wasn't it?" Chandler asked Earl Perrine. As an assistant roadmaster, Perrine did the twice-weekly inspections. Perrine retired in December 1996 after 44 years working on Curve 155 territory. "They started looking at it," Perrine answered. "It was never transposed, was it?" Cox objected. The plaintiffs had never made a claim on this point, and this was true. This was a violation of MRL standards, Chandler asserted. Erickson allowed the questioning. Perrine said they had started looking at it for the next year. 1992, 1993, 1994, 1995. It never got transposed, did it? Chandler asked. No. Chandler left it at that. He had proven that MRL violated their own transposition rail wear policy on curve 155 and had even let it go for many years. MRL then called their liability experts. Gary Wolf made one slip in court, Freudian or otherwise, when he said, "I think this is the first A-rail I've seen that had a vertical split head." Intent on his questioning, Lyon didn't even catch it at the time. Lyon ended his examination with his signature cluster of closing questions. Between 1968 and 1996, what changed in the rail? Wolf: nothing changed in the rail. Where? That goes without saying, Wolf said. There also could have been subtle structure changes, he allowed, from random wheel load impacts. One major difference, Lyon prodded? He wanted Wolf to name it. Obviously, the rail wore, Wolf said. Through his investigations, Wolf had found that most derailments were traced back to human error. That is, broken rail overlooked. Lyon brought out in court that Wolf wrote a document called Derailment Investigation Fundamentals, in which Wolf stated that the root causes of derailments consisted of inadequate company standards, lack of compliance with those standards, and lack of a formal structure with which to meet the standards. Lyon wanted to suggest the book described MRL. But MRL expert Don Holfeld echoed the sentiment of Keller that while most derailments were preventable, some appeared to be unpreventable, an act of God. By MRL's account, Alberton had been inscrutably fated by the invisible hand. During a break, Potter muttered amiably to Lyon, "We have you in a hole." Lyon did manage to get on the record Jude Igwemizi's $1 million in expert fees over the past 5 years, writing the figure on a big sheet of poster-sized paper for the jury, one of his favorite props. On the 8th day of trial, the weather turned unseasonably gloomy, overcast with fog, sleet, wind, and temperatures in the 30s in the morning, not unlike 5 years earlier on that same date, April 11. As the rail experts concluded their testimony, the courtroom climate looked increasingly ominous for the plaintiff as well. On the last full day of trial, Randy Cox put on the stand Rick Bitts, an MRL engineer on the last train prior to Caswell and Shutters. Bitts explained that when an engine went over broken rail, it gives a pretty good jolt, felt in the wheels and in the cab seat. You only heard something if you're going slow. He would call it into dispatch, which would then notify the section foreman. By April 11, 1996, Bitts said he had been over curve 155 42 times that year and never noted a problem. Early on April 11, Bitts and his assistant engineer were a dog catch crew in relief of the eastbound crew just off the clock in Superior. The track warrant they carried had no warnings regarding curve 155. When they passed over the curve around 12:30 a.m., the last train before the catastrophe, Bitts said they felt and heard absolutely nothing. Cox next examined engineer John Caswell. He and Shutter had last gone across the curve on April 9, and neither one felt nor heard anything. No pothole-like bump, no jog. During his cross, Chandler asked Caswell if he received any visits from other engineers in the hospital. Train crews carried Form A, which informed them of track conditions. Did the visiting engineers show Caswell the form, and did it show a lot of rough spots? Erickson sustained Cox's objection. Fisherman Chandler apparently had nothing specific on curve 155, or no solid evidence. Chandler then asked if Caswell told Potter in deposition that he did not trust MRL. Objection sustained. Chandler asked Caswell whether after the derailment, was it true that he didn't trust MRL and that he didn't think they ran a safe track? Objection sustained. Irrelevant. In fact, Caswell had said in his deposition, "I don't trust the company anymore," though the point was not elaborated. At the time, he had a claim against MRL. Though the majority of the trial was a fight over MRL's liability for the derailment, a case still had to be made for Sam Austin's injuries. In the years leading up to trial, MRL steadfastly denied Austin's symptoms were connected to his chlorine exposure and argued any pre-existing asthma condition was not affected by it either. According to his doctor's testimony, the chlorine exposure permanently re-triggered Austin's abated childhood asthma based on his continuing symptoms and moderate reaction to a methacholine challenge test. Dr. William Hewson diagnosed Austin with chronic inflammation of the airways and bronchial restriction triggered by irritants. Austin also had developed exercise intolerance. He would be on inhaler medications for life and would be more susceptible to respiratory pathway infections. Hewson said without the derailment exposure, Austin would have no symptoms today. Lyon also put on the stand Dr. Michael Nakar, a Texan toxicologist with a PhD in environmental science. Nakar wasn't hired only to present the toxicological effects of chlorine on Sam Austin. He reviewed the cases of 68 other plaintiffs, a fact which Lyon got out before Cox's objections. But Lyon pressed on. In arriving at a toxicological assessment on Austin, Nakar had performed a differential diagnosis and epidemiological study, which entailed considering whether other Alberton victims had similar symptoms during the exposure. Nakar added he also reviewed the ATSDR Alberton study. Not wanting this broad view elaborated upon in the record, Cox abruptly stood up and conceded that the exposure to chlorine had exacerbated Austin's underlying asthmatic condition. When Lyon asked at what mathematical certainty Nakar had arrived that Austin's symptoms were caused by his exposure, Cox jumped back up to object, saying, "I'll give him 100%. I came up with 99.9%, Nakar said. "I got what I wanted," Lyon said. When Cox made his concession, Lyon wrote down on his poster-sized paper for the jury, "Randy Cox says 100%. Lyon later said he had been surprised at Cox's maneuver, but that Cox gave the 100% in order to get Nakar off the stand and stifle any more mention of other people's symptoms, which might have lent credibility and sympathy toward Austin. About 16 other Lyon clients had reactive airways disease, and 39 of them had upper respiratory problems. MRL was finally on the record as having admitted a chronic injury from the Alberton spill. The courtroom battle then turned to how serious Austin's health problems were and any compensation. MRL's medical expert agreed that Austin had mild pulmonary obstruction and was a mild to moderate persistent asthmatic, and even said that Austin possibly had developed RADS due to the exposure. But he also suggested that Austin mismanaged his treatment of inhalers and could otherwise be asymptomatic, reflecting the common MRL defense tactic to blame the victim. Lyon also called on an economist from the University of Montana who concluded Austin had potentially lost about $185,000 in future earnings, considering his demographic and a 4-year setback in his education plans. Factoring in some disability could greatly increase that. The jury had a lot to consider. Amid the liability debate over worn rail, A-rail, the missing Keller rail, and exactly how the defect had originated, MRL flatly argued that they had no warning or prior knowledge about the vertical split head. The best the plaintiff could counter was that MRL should have known, arguing rail wear, other derailments, questionable inspection practices, and the Sperry tape. Meanwhile, MRL finally conceded that the chlorine cloud permanently harmed Sam Austin. But in order for Austin to receive a penny, the jury had to find MRL negligent. Next time on Gas, the true story of a toxic train derailment. Prior to his closing argument, plaintiff attorney Ted Lyon ruminates on the Alberton litigation. When the verdict is announced, one side celebrates while the other is angry, and the jury foreman feels duped by the process. Until then, this is Ron Scholl. Thanks for listening. This podcast is adapted from the book Gas, the true story of a toxic train derailment. Visit Amazon.com to see the 2-book series. To access support material in the book, such as maps, photos, illustrations, and video links, visit my Facebook page Gas, the true story, or watch my Gas playlist on my YouTube channel at RL Scholl.